behalf of the Secretariat, we are really grateful for you sparing your time and accepting to speak on this very important subject. And I would like to really thank you, Irene and Robert, for jumping in. Unfortunately, Mr. Bizoromei and Mr. Mutibwa were unable to speak, but I'm glad that you agreed to chime in and take this conversation ahead. We'll be streaming our session live on Facebook, YouTube, and LinkedIn. And we do have a total of 300 participants that have already intimated their desire to join the session. Already in the waiting room, we have 28. So by the time we start the session, there will probably be a very big number ready to join. It's good that we are here. I don't know if we've already gotten a briefing from Ruth because I was in a meeting, so I delayed. And so Elma tells me that we are live already. So I think we'll give it uh, about 3 minutes and then start off at exactly 2 minutes or 3 minutes past the hour of 2. But you're all very welcome. And to our participants who already uh, logged on, we are honored to host you. We look forward to having a wonderful session with you. And let's tweet and share. We are live, like I mentioned. And for now, I'll probably hand it over to Ruth to have some housekeeping rules, and then probably we'll start the session officially in 2 minutes. So Ruth, I'll hand it over to you now.
Okay, good afternoon, everyone, once again. So, thank you so much for taking your time to join us this very wonderful afternoon to deal and talk about the art of contracts, mastering the art of contracts. We are very grateful. So we are going to, first of all, begin with the introduction into the session, and then we'll go to Irene, and then we'll introduce Irene Namuli, and then we'll introduce Okot Robert, and then lastly we'll finish with Cindy for the panel discussion. Thereafter, we'll go to the plenary, and then we'll have our closing remarks, and then we'll go off to move on with our day. So I think we're ready to start now, Gabriel. Okay, I think we can begin now. Good afternoon, everyone, once again. I'd like to welcome all of you to today's webinar on mastering the art of contracts. My name is Ruth Vuchocho. I'll be your moderator today for this session. And I want to thank all of you for joining us. Whether you're a seasoned professional or whether you're joining us as a newbie to the field, we are happy to have a diverse group of participants today to discuss this art of contracts. We are all aware that contracts are a cornerstone of any business relationship. They lay down the foundation of relationships in business, in so many other things. And we are here today with our very wonderful panelists who will help us to understand the nuances that are critical in ensuring that we foster proper relationships built on solid foundations, and that we ensure that we meet our clients' needs. We ensure that we understand the foundations of our clients' needs. Today, we'll be diving into the key aspects of contract law. That is what to do and what not to do in practice. We shall explore some of the best practices, and we'll discuss how to navigate some of the common challenges that we experience as practitioners and even as the other people that are participating in this wonderful session. We have an exciting lineup of speakers who are excellent experts in the field, and they're here to share their understanding, and their insights with you. That is based on their experience and based on what they've learned. And they'll be covering the importance of contracts and the key considerations that legal practitioners and also other people who are in these contracts ought to take while drafting these contracts. There'll be plenty of time for the questions during the plenary session. But before we begin, I just want to note that we will be moving fast. We will be starting with our very, very wonderful panelists, Irene Namuli. She will be dealing with the foundational concepts of contract negotiation and drafting. Thank you so much, Irene, for taking this time to join us. Irene is the head of corporate in the head of corporate and commercial department at her firm. And she's also the vice chair for the corporate law committee at the East Africa Law Society. She has expertise in banking and finance in various entities, private entities and public entities. And she'll be guiding us through this session. And I hope that we are ready to learn. We are ready to take home insights. We are ready to gain from her experience. So thank you so much, Irene. I'll be inviting you to begin the session for us and have a good time. If there are any questions that anyone might have, perhaps you can share them at the Q&A or share them on the chat, and I'll be able to note them down. And then I'll pose those questions to whoever they are directed to at the end of the session during the plenary. Thank you so much, Irene. I invite you to take over.
All right. Thank you so much, Ruth. Good afternoon, esteemed colleagues, ladies, gentlemen on the call. Thank you so much for joining us. Today, as Ruth has said, we are I'll start the session delving into the foundational concepts that we as legal practitioners should master or should take into account when negotiating or drafting contracts. Whether we're working on a simple agreement, a complex agreement, commercial deals, we're doing mergers and acquisitions, there are certain core principles that we need to look at and equip ourselves with so that we draft contracts that are effective, are enforceable, and beneficial to our clients. And so we'll start with a very simple basic. What is the definition of a contract? A contract is a formal agreement between two or more parties that creates a legally enforceable right or obligation, and it should be enforceable. For it to be enforceable or valid, it must satisfy certain legal requirements, which we'll go through as we lay the foundations before we go into the principles that we need to look at. So all of us have, studied law, obviously, and we remember the law of contract. There must be an offer and there must be acceptance. Each party must make it very clear what the offer is, and the other party must give unqualified acceptance, or in simple terms, they must accept the offer without any modifications whatsoever. So where there is offer and acceptance, then we can go ahead and say we have a contract being put in place. we need to have consideration. Of course, every party must provide something of value. It could be money, we could exchange money for services, or it could be a service for a service, or it could be goods. So either of that, as long as it's something that is valuable to the other person, then that is consideration, and we can assume that that is a contract in the making. We also need to have mutual intent. This is the intention of the parties. Both parties or all parties, whether 1, 3, 10, must have an intention to create a legal relationship and to be bound by the terms that they agree before they are put down on paper. So as we reduce this intention and agreeability of the parties into a contract, we must take into account that there has to be mutual intent, because it's a contract is really a meeting of minds. And then you have to consider capacity. Jurisdictions all over the world agree that anybody who's mentally incapacitated, a child, cannot enter into a contract. So the person or the parties must have a legal ability to enter into a contract, meaning they must be of sound mind, they must be of legal age, and they really must be able to represent. If it's a company that is entering into this contract, this person must have been given authorization by the company to represent it. So we usually want to deal with people like directors, because the law authorizes, at least in Uganda, that if a director signed a contract on behalf of the company, then it would be ratified as if the company entered into that contract. And then, of course, the legality. We cannot forget that. We should not be the people who help other people break the law or enter into contracts that are null and void or unenforceable or voidable. So contracts must have purpose. They must be lawful and not against any public policy. You cannot have a contract that's repugnant to the public. And then we look at certainty. The terms of the contract must be clear, that the parties must, and that each of the parties is able to understand their obligations, their rights, and what is expected of them. You don't want to have something that's ambiguous, where one party says, I wasn't sure what I was supposed to be doing, or I didn't know what I was signing. They must be clear. In fact, most of us, like, for example, I'll give an example in Uganda, even something as simple as a mortgage deed. There is a requirement that the person must certify that they're literate and that they've sought independent legal advice. In other words, they've had this contract explained to them before they put their signature on it. So they cannot come back later and say, oh, I'm illiterate, I didn't read, or some of the terms were very complicated, I never understood them. So that certainty, each party must be understanding of what is in the contract and what is expected of them. And so with that basics, we move to understanding why are contracts important. In the context of either personal or business, we know that anything that is written, that is not written, is subject to abuse. So we put down these contracts, one, for clarity of rights and obligations, where I've just been. So when there's a clear record of what each party is expected to do, we minimize the risk of misunderstandings and disputes. That is one of the reasons why we need contracts. And then two, the legal enforceability. Once we've signed the contracts, it becomes legally binding, and then it allows the parties to seek legal remedies in case there's a breach. But also, if somebody needs a reprieve or they need, it can be relied on that, you know, I had a contract with this person and I'm able to do X, Y, Z, or they authorized me to do whatever it is that the contract was about. And then it is also good for risk management. So when we've outlined our responsibilities as per the contract, then we mitigate risks associated with our transactions. You do not want to be in a situation where one party says, no, we agreed that you'll bring me 10 kilograms of XYZ, and the person says, no, I said 5. And so you have a dispute that is arising and parties being disagreeable with each other. But when we have written the contract and outlined what is expected, what is the obligation, I am importing a car from Toyota, and I have agreed with Toyota that the car, these are the specifications. This is going to be the chassis of the car. This is the number of axles I'm expecting. If I receive a car that is not within the specifications, I have redress. And also for Toyota, they have a basis of which to make sure that the car is within the specifications I have requested. And then lastly, why we need contracts to formalize our relationships. Most of us, we do gentlemen's agreements. Most of us in East Africa, our culture allows us. We shook our hands on it, and so it's a contract. But where we are going, different cultures mingling, we are doing businesses across borders, a lot of things get lost in translations. So when we have formal agreements like contracts, we enhance trust and cooperation, especially when it's business, we're dealing in business. Because for some people, a handshake is good enough. For some, it may not be. We don't have the same levels of trust. I've had situations where people went to import goods from China, and because contracts were never signed or it was emails exchanged, at the end of the day, when things went belly up, one side says, listen, I never said I was going to send you whatever. I said I would send something, and I've sent samples. Or I only said I was going to send you 100 bags. I don't know if you guys saw a video somebody put, I think, on TikTok, that they ordered for, I think there were about 80 bags from handbags from China. And the negotiations were done, everything, contracts, and there was no contract. I think they did the negotiations, payments were made, and these guys sent proof of shipping. They actually shipped the goods. And so the goods arrived where they were going, and the person opened them, and what they had sent were tiny little bags, like they were as if trinkets. They were like trinkets. And so when this person goes back and says, but these are not the bags I ordered, the person said, you ordered 80 bags and we sent 80 bags. So, you need to formalize your relationships when you're doing your contracts. Now, let's look a bit we are talking about drafting and negotiating contracts. So let's look at our negotiation strategies, because let's face it, as lawyers, you're on one side, you're either negotiating the contract, you're drafting the contract, but either way, there's still a discussion that goes on, which we call the negotiation. And it's as much as an art as it is a science. So when we negotiate effectively, we not only, help our clients achieve whatever their interests are, their best interests, but also to get the best out of this. So we need to come in understanding both the legal and practical aspects of the business we are negotiating. So as a lawyer, it's not enough just to know, oh, I draft the contract. Sometimes you also need to come in and help the parties to negotiate, because they may not have a very good understanding. There may be knowledge that is within your purview as a lawyer because of the vast experience you have. So it is important that we take part in the negotiations and not just draft the contracts. So when you're negotiating, preparation, it's as simple as that. Understand and know your client's objectives. What do they want to achieve as they're entering into this contract? What is the other party likely to counter with? And also them, what are they looking for? So that you are able to find what we call in negotiation, what we call the ZOPA, the zone of potential agreement. As a lawyer, it is your obligation to ensure that you get the parties as close to that ZOPA as possible. So you have to prepare, know what the other party is likely to ask for, what your counter proposal will be, and where you might be able to meet in the middle. So even when you're negotiating, you're moving closer to the ZOPA. And also you need to know the legal landscape. You're not going to encourage your clients to come and negotiate contracts or business transactions that are illegal. You need to know the legal landscape. You need to know that, in maybe last year, XYZ was agreeable and understandable, and this time it is not. Right now we have data protection has become a big deal all over the world because of the various infractions that have happened. As a lawyer, as you're negotiating, depending on the landscape, you need to know if this contract actually requires that they put in place data protection mechanisms. You need to have prepared, you need to know You need to be prepared. You need to know your clients' objectives, what are their interests, how do you protect them before you go into the negotiation. And then the other issue is flexibility. Even when we have, sometimes we're not clear. I want this, but I'm not too sure how to get it. So you need to have flexibility. Allow people to, maybe they came with a very set mind, and I want this. And then when the negotiations began, you realize that maybe it's not in their best interest. And so you need to be flexible and be able to compromise on less critical issues, adjust where it's required. But most importantly, always stay focused on the goal of what your client requires and what is the most important. What are the most important terms and what must be adhered to, what can we leave and what is a must and do or die. And then the other thing is, as we are negotiating, let's not forget we are building relationships. On one day you are negotiating for the other side of the table, on the other day you're moving to this side of the table. As lawyers, we need to ensure that we foster relationships, not just for our clients, but even for ourselves. So when you come in with a mindset of it's a win-win outcome that I want to get from here, let's first remove the courtroom where one party loses and the other wins. In contract negotiations, we are looking for a win-win outcome. Each party gets the best negotiated position possible. So negotiate with that in mind. You're building the relationship and fostering long-term, transactions and relationships between the parties. So quickly, that is, the basics that we need to know. And so I'll go into the foundational concepts that we should consider when negotiating or drafting contracts. And I'll go through those as well. Again, I cannot overemphasize, we need to have clarity and precision of terms. Ensure that the terms agreed upon reflect the intentions of your clients, the rights that are accruing to your clients, and the obligations of all the parties involved. Because ambiguity, where we're ambiguous, we're not too sure about the terms, you could end up with an unenforceable contract, or you could undermine what we call the autonomy. In contract negotiation, we have something we call the autonomy of the parties. So that could be a risk that ends up there. So use clear language. I know lawyers, in the past, we loved using Latin maxims and the King's English, thouest and doest, and there are 4, but let's try and avoid legalese unless it's absolutely necessary. Recently, I drafted a contract for a client and I put all, this was, as per the contract between the parties by date XY. And they came back and asked me, is this English? And so I realized that for me, it made sense. For the client, it didn't make sense. So let's try and use clear language so that it's straightforward and easily understood by the parties. Also, define the key terms. You don't want to read a contract where you're trying to look for a dictionary and then asking, what does this mean? And then, you're not meeting. If your terms are defined clearly, everybody is on the same page. If in the contract we've said money means, the value that is being exchanged, or we've said whatever means X, each party is on the same table. So it reduces the risk of disputes over the meanings later on, because if you've put in terms that are understandable to the parties but mean something different to third parties, then interpretation could be a problem. And then we need to, again, be specific. Vague terms or clauses can lead to litigation. So be precise when describing your duties, obligations, payment terms, if any, timelines, conditions, remedies, just everything has to be specific. The second foundational thing that we need to look at, your document structure. Many times we've looked at contracts that are zigzag and disorganized. One clause is this side, and then we're talking about dispute resolution, but there is part of it in the introduction, then there is somewhere in the middle there, then, that is really, it disorganizes, and it doesn't show that the person understood what they were doing or even make it easy to enforce. Because if you have a clause that is, or a subject matter that is being addressed in 6 different clauses, which are talking about totally different things, can be a bit disconcerting and when it comes to understanding your documents, it could be a problem. So when you're preparing your contracts, look at the structure, make it easy to read and understand, have a logical flow, start with the basic terms, the parties, the recitals, the definitions, then move to the operative clauses, obligations, rights, and then conclude with your standard or boilerplate provisions. And then also your headings and subheadings, use them to break down the document into manageable sections so that it's easy to navigate, but also for parties to find what they're looking for. It's very easy. If I'm looking, how do I terminate the contract? I should be able to find it under either the heading or subheading termination, as opposed to having to read an entire document to look for that particular aspect. And then just for neatness, I like to have consistent formatting, because you don't want to read a document that is in font X and then it's coming in Calibri at some point, then it turns into Times New Roman. Be consistent with your fonts and your spacing. This helps to promote, readability and also avoid confusion. The other foundational concept we can look at is balancing party autonomy. I think I'd mentioned it earlier. So in party autonomy simply means that when parties are entering into a contract, they have the freedom to choose the terms of their contract without influence from third parties. For example, if I'm going to get into a contract with my best friend to sell them my watch, party autonomy simply means the two of us can sit and agree how we are going to exchange this watch. I could say, I'm going to give it to you for $1. Is my watch worth $1? Maybe not. But because, we get to choose the terms of our contract, it is all right. However, we as the practitioners, as we come in to assist with this negotiation and drafting, it is our duty to know the laws and regulations governing that particular transaction or activity that is the subject of the contract. Is it allowed for me to give a watch away for $1 or to sell my watch for $1? Yes. On the other hand, can I tell this person I'm going to give you my watch and for the next 100 years, you're supposed to give me all your lunch money? Maybe not, but we need to know the law. And so we must ensure that the parties comply with the laws and regulations, public policy, and as I mentioned earlier, things like data privacy and protection provisions where necessary. In some instances, even consumer protection must be included in the contract. So as a lawyer, you should make sure you balance the party autonomy, even as the parties would like to contract as they wish. Let's say it's a money lending agreement and one person is saying, for me, I want to lend you my money at 30% interest daily. Is that okay? In terms of autonomy, yes, but legally, is that allowed? You need to look at the laws in your country where you don't, in Uganda, I think you're not allowed to compound interest. So you need to be able to know things of that nature. Another foundational aspect we can look at is risk allocation and mitigation. Of course, the contract, by its very nature, is mitigating risks. But then now we also need to know how to allocate it, because sometimes you're coming into a contract where both parties are either going to assume the risk or one person is assuming the risk. So one, identify it, allocate it, and mitigate it. And how do we do that? Ensure you have indemnity clauses in your contract. So determine who will bear specific risk and how they will be compensated or how it will be dealt with. And then you could also have limitation of liability, cap the potential liability of your client. Always come in and know that, okay, if we are doing XYZ, this is where we stop. We can't say we will reimburse you or we will indemnify you up to X amount of money. You don't want to expose your client to unlimited liability. So either sometimes you will want to exclude certain types of damages, or you could say, you could define how your client would mitigate any potential liability that's coming their way. Some contracts will necessitate punitive or consequential damages. Write it out. Make sure you have a limitation of liability, so you don't have a contract where your client turns out exposed to $1 billion when they did business that was worth only $100,000. And then also let's look at warranties and representations. That is still part of risk allocation and mitigation. Clarify that what the parties guarantee, either presently or in the future, as the contract is ongoing and being performed. And where there's breach, consider the remedies that are going to be available to the parties if these guarantees are breached. The next foundational thing we can look at is the standardized clauses, which we call boilerplate. Sometimes we overlook them, but in the event of a dispute, they could become an issue. And one of those always is the governing law and jurisdiction. We should never forget, because you must specify which law will govern your contract. And if you have litigation as part of your dispute resolution, then which courts will have jurisdiction over any of your disputes. A lot of transactions now are cross-border. We are doing international contracts. So we need to make sure you don't want to have, one time we had a contract here that was signed in the US. The sponsoring party was in Zurich and the enforcer was in the UK. And so in a situation like that, if we had forgotten to include which law governs, then we would reach a problem, or we're having a dispute and each party is saying, I sit in this country, we are using my law. And you realize that all those three countries have different different systems. So where would we go? We just agreed and said, okay, we will have a mutual ground and this is what we will follow. So don't forget that, always have. Ensure you include those terms that protect your client's interests. And then there is the entire agreement clause. Ensure this clause is present to confirm that the contract represents a complete agreement between the parties and supersedes any prior communication. Sometimes negotiations go on for a long time, and during those negotiations, people talk and agree and exchange ideas. And at the end, somebody comes back and says, "But you remember the other day you said." Now, when you've included this, that this is the only contract that is binding on the parties, the entire agreement clause, somebody cannot rely on what was said or whatever was mentioned at some point, as long as it's not in the contract. And then, of course, there's the force majeure. I think COVID has taught us that this is very important, because most times we put it or we don't put it, but don't forget about it. Protect your clients from liability, from unforeseen events that may make performance impossible or impractical. So that way they have an out. I think until recently, China was even still giving all their manufacturers the force majeure certificates to show that they could not perform or perform their obligations under many of the contracts that they had because of COVID. And then another foundational aspect we should look at: review and adaptation. Contracts should never be static. As we wrote it in 1900 is how it is in 2024. Anticipate potential changes and circumstances. The law could change, the regulations, the policies. So draft contracts that are adaptable and relevant to the client. Their business could be affected by a law reform. So have that flexibility. When you're drafting, include periods of review, especially if that contract is long-term. Like, for example, it's going to be 5-10 years. Include a clause where they can review the contract maybe every year, every 6 months, or every 3 years, to ensure that they adapt with changing circumstances or outdated and impractical terms that are no longer relevant to them. And then there is also amendments and modifications. You should have provide for that in case it is needed, because sometimes we enter into a contract and along the way things happen. So you should have that flexibility to either amend or modify the contract, because if we do not have the provision in, it could be a problem later and could cause problems or make everything unenforceable. For example, if you wanted to modify the time of delivery, but the contract does not give you that leeway to amend or modify, and then even if you have a discussion and the other person changes their mind, they can come back and sue your client over the terms of the condition. But if you agreed that you could amend, then you could just do an addendum and say, much as we said delivery is in 60 days, circumstances XYZ, so we've increased it to 120 days. And then do not forget another foundational aspect and principle we should always look at is dispute resolution mechanisms. Agree how to settle your disputes. Is it through litigation, arbitration, or mediation? These clauses are very important so that in case there is a problem between the parties, they are able to know how they go about it. Do they go straight to court? Are they going to do arbitration? How do they appoint the arbitrator? Where's the seat of arbitration? Which language is it in? Even for mediation, you do not want to leave this until the end of the dispute, because by that time the parties are not seeing eye to eye and they'll disagree and make, escalate the problem, which then probably leads to financial loss or whatever risk that they were trying to mitigate in the first place. And then last but not least, do not forget your termination or exit clauses. It is always important to state under which terms a party may terminate or exit the contract. Are they required to give notice? Is it in writing or verbal? What is the duration of the notice when termination happens? What causes, what triggers termination? This ensures clarity for both parties. We once had an agreement that was entered into between an entity and a production house that was producing a series, and everybody was excited about the series. And season 1 was on fire, and so we entered into the contract, signed, and everybody was happy. Money was exchanged. Season 2 came, and it was not as exciting. And so the person who was sponsoring said, "I need out of this. I want to terminate." And lo and behold, there was no termination clause. It looked like the contract was for perpetuity until these guys were tired. So imagine such a situation that automatically causes financial loss. So in conclusion, the foundation and effective contract negotiation and drafting lies in clarity, provision, and deep understanding of both the legal principles and the practical realities of the business world. So when we master these foundational concepts, we can serve our clients better, mitigate their risk, and craft contracts that stand the test of time. Thank you so much. And as Ruth explained, we will answer any questions within during the plenary session. Thank you so much.
Okay, thank you so much, Irene. That was such a wonderful session. We must all agree that in legal practice, mastering contracts is a game changer. As Irene has said, it's everything. And she has also mentioned that you must always stay focused on the goal. What does your client need? What do you need to achieve? What are your objectives? Ensure that you negotiate for your clients, know the expectations, understand the legal landscape of whatever you need to do, carry out your research as legal practitioners. And I think one of the things that I have taken from her session is that anything that is not written is susceptible to abuse. And I think that's very important for all of us to understand. Now, even as we move into this next session, I shall be introducing Robert Okot, who shall be handling the pitfalls lawyers often fall prey to while drafting contracts. Robert's focused areas are in regulation laws, international law, human rights law, and I feel like he's going to be very insightful. His practice is including drafting of documents for international bodies and all those other entities. So we look forward to an informative session from yourself. And thank you so much and welcome, Robert. I'll invite you to take over from me now.
Thank you very much, Ruth. And also, good afternoon to whoever is attending this session. Thank you, Irene, for that wonderful presentation. Personally, I'm always working with largely non-profit entities, and in there, I keep interacting with either employment agreements or contracts, or you're dealing with grant agreements, cooperation agreements, but also could be procurement agreements, things of that kind. Irene has spoken quite a lot, or somehow preempted this session, but that's also very good. And as stated, my role is to try and outline some of the common pitfalls that lawyers often fall prey to while drafting contracts. But just as a starter, I'd like to note that contract drafting requires precision and expertise such that both parties are happy. Because in contracts, every detail, every word matters. And it becomes imperative to avoid mistakes during the drafting of legal contracts. But before we even get into the mistakes or pitfalls that lawyers often find themselves in, we certainly need to understand the responsibility of the lawyer in this process. And we can note that the lawyer's responsibility in this process can vary depending on the specific needs of their clients. Yeah. However, there are those responsibilities that cut across. Yeah. You're either going to be drafting or reviewing or negotiating the terms and conditions or providing legal advice on specific contracts. And also sometimes ensuring that contracts comply with relevant laws and regulations. That is if, of course, when drafting contracts, lawyers again must carefully consider the needs and interests of their clients, while also ensuring that the language used is clear and legally enforceable. I think Irene had already said something about that, ensuring that contracts are very clear and drafted in an easily understandable language. So I looked at some of the mistakes that we lawyers make, and one of them is failure to understand the critical issues. Am I audible now?
Robert, I think there's a problem with your audio. Perhaps maybe you can look at that.
Am I audible now?
Yes, I believe we can hear you now.
Okay. I was just saying that before we even get to understand some of the mistakes that lawyers make in drafting contracts, we probably need to first understand their responsibility. And I looked at, it could be drafting and reviewing contracts, it could be negotiating terms and conditions, it could be providing legal advice in contract-related matters, it could be ensuring that contracts comply with relevant laws and regulations. All those are responsibilities that lawyers should be undertaking when drafting contracts. But in all this, lawyers must carefully consider the needs and interests of their clients, while also ensuring that the language used is clear and legally enforceable. And I think I'd already stated that Irene had ably discussed that. But I'll look at a few other mistakes that we normally make. Number one, failure to understand the critical issues. Personally, I normally want to have my clients verbally communicate to me a rough outline of the agreement as they understand it before I put pen to paper. Usually, these are the issues that are foremost in the client's mind. And it's important that as lawyers, we address those concerns first. Next, before I begin to draft a contract, begin to draft a contract, I like to address my thoughts on the contract with my client and hear what they think about my ideas. This certainly helps both of us to be on the same page and be acquainted with the salient issues. And of course, this process serves as a good starting point to discuss other critical issues that might have been previously overlooked by my client or myself. Number two, failure to be specific with the contract terms. Again, Irene had alluded to that in her presentation. However, you have probably had many poorly drafted agreements or contracts come your way that needed you to draft them afresh or rework them. But this could have been maybe because of lazy drafting. For instance, one could put there a clause that says the parties believe they can work out a parenting plan that is fair and reasonable. This certainly is very ambiguous and will definitely cause trouble. And as a lawyer, what you have to do is be specific with the terms, and then you can always deviate if you agree to do so as you move forward. Because as Irene earlier stated, clarity in all things contractual is very key. Failure to examine existing templates. I know we all love using templates. However, we need to understand that every client's interests are unique to that situation. Yeah. So even when you have a template that has a situation that is similar to your current client's needs, you still need to thoroughly examine that template such that you can be able to tailor it to the needs of your current client. You need to find a balance between efficiency and usefulness for the client. Generally, in drafting documents, you need to find out your client's specific and subjective requirements and goals. And if you have those in mind, you can start to draft a general document, refining it over time and again for your client's specific needs. Next is failure to proofread. The mistake that I see some of our colleagues often making arises from poor copy and pasting. You have a transaction you previously worked on. It's similar, so you basically copy what is in that contract or agreement. You want to use it in your current client's transaction. However, you don't even take time to proofread or even do a peer review or have a colleague review it. Yeah. Chances are that your client's interests will be jeopardized. Yeah. Of course, sometimes you could receive a client that has gotten a template from the internet. Yeah, there are those clients as well. Yeah, and then sometimes it could be a document that is coming from another firm. Yeah, and they are probably using a transaction similar to one they have previously handled. Yeah. However, if you do not do thorough proofreading, your client's interests are likely to be jeopardized, as earlier noted. For instance, you might find mistakes like names, addresses, yeah. Even if you had used, let's say, spell checkers or grammar, those mistakes will not be identified. Again, the other example I could use, sometimes we do cross-referencing in contracts or agreements. Yeah. So you refer to, let's say, clause 1, paragraph A. Yeah. But because you are relying, after doing some revisions, the content may be changed or deleted. But you may not have changed those references alluded to. Yeah. So we need to do a lot of proofreading. At least if you have 3 other colleagues look at your document, that would be fair enough, not just for you, but for your client and but for your client's interests as well. Failure to make the contract easily understandable. Again, Irene had already talked about that. However, just to add, when drafting a contract, it is important to make sure that any person, think of, it could even be your grandmother, yeah, can read the contract and clearly understand each party's obligations under the agreement, and the remedies available in case one party fails to perform. Of course, as well as we like using legalese, yeah. But when it comes to contracts, it is desirable that we use the simplest or plain language, such that we don't have parties misunderstanding their duties and obligations. Again, in trying to make sure that the contract is easily understandable, we need to always ensure that the remedies are clear. For instance, the contract might say X must do A, B, C, D. If the agreement or contract follows the obligation with a remedy in case X fails to perform, or in case X fails to perform, then the other party will spend a lot of time and money to enforce the contract. Again, that is something that Irene had talked about. We need to ensure that the agreements or contracts are clearly understandable or easy to understand. Failure to incorporate arbitration clauses. Of course, we are in an environment whereby we are heading towards a lot more alternative dispute resolution. So when looking to draft a contract or an agreement, it's important to thoroughly read through the document and ask yourself, what should happen to the agreement should someone refuse to comply with its terms to the dot? For instance, you could address scenarios in which a party no longer wants to comply with the deal. The contract should include practical, inexpensive ways to enforce the parties, to make the parties comply with the terms of the agreement. Because it's not enough to be able to sue the non-complying party, because a lawsuit may require time and resources that are more troublesome than if you had, let's say, included an arbitration clause. Failure to do thorough due diligence. Yeah. Of course, sometimes we get challenged. A client comes to your chambers on a Friday evening, your pockets are empty, yeah. You are getting into a weekend, a child needs to spend on one of his orgies, and then there's this client who wants you to help them draft a land sale agreement. Yeah. And they want it immediately. They're even offering you some good amount of money. Yeah. You certainly have no time to due diligence as a lawyer. However, the fact is you need to do a due diligence. Before you put that pen to paper, you should first obtain all the information, verify what your counterparty is telling you. Without that information, it's possible that you will make very serious mistakes. And please, we advise that we shouldn't be satisfied with emails or written representations of the other side, because everything that is said to be true can actually be fact-checked by an independent third party. Is it ownership of a title, proof of funds? Is it about expertise? Of course, there will always be a government entity or bank or person of reference that can tell you if a non-compromised side of the story. Therefore, if you don't do your due diligence properly, you might not be able to properly draft that agreement or contract. The other mistake that we normally make is failing to analyze all possible situations. Okay, you may not be able to analyze all situations, but you need to take trouble to try and look at as much as possible all those situations that could come up. Yeah. One of the keys to contracts is to think through all of the likely what ifs. Yeah. It helps you have it helps you find solutions should any of those things happen. Yeah. For instance, if you had a partnership agreement, you would need to be crystal clear on what happens if something goes wrong. Now, if you find a partnership agreement or partnership deed that says that we shall reach an agreement about the business if we disagree, that would certainly be an example of an ineffective or ambiguous clause. Instead, if you had a clause that, for instance, says, if we disagree, we will sell the business and split the proceeds. This is much more clear. And should there be a disagreement amongst the partners, it will be clear on how they part ways. Friends, as I conclude, I would like to state that to provide contract drafting services, we need to have a thorough understanding of all the significant details of the transaction. And as lawyers, we should strive to achieve the same with undivided attention and diligence. Thank you.
Wow, Robert, that was quite interesting and insightful to learn. We've all taken note that whether you're navigating complex negotiations, whether you're drafting airtight agreements, it's important to have the right strategies at your fingertips. As Robert has indicated, you need to look at your responsibilities as the advocate so that you can avoid the pitfalls that he has mentioned. What is your responsibility in that contract? Are you drafting? Are you ensuring compliance? Are you negotiating? Are you offering legal advice? Ultimately, you must mitigate the risks. You must ensure that you meet the obligations of your client. And even as we discuss this now, we will move to our third and last panelist, who is Cindy Oraro. She is a partner at Oraro and Company Advocates in Kenya. She's basically an expert in commercial practice. She has specialized in energy and infrastructure projects. And I believe her over 12 years of practice will be advantageous to us as legal practitioners in order to understand how to plan, draft, and deliver our contracts. Now I'll introduce Cindy Oraro, who will be talking to us on the best practices lawyers can employ to avoid the common pitfalls in contract drafting. Cindy, thank you so much for joining us today. We are honored by your presence. And now I'll give you this opportunity to speak to us and share with us your knowledge from your expertise. Thank you.
Thank you very much, Ruth. And thank you also to my fellow panelists, Irene and Robert. They took us through some very important principles that I will also reiterate in my presentation. So I have a PowerPoint presentation, which I will share just now. And essentially, I'm going to talk about avoiding the common pitfalls in contract drafting. So again, it's important to understand, to refocus on the foundational principles, as well as some of the pitfalls that Robert highlighted. We have to focus on the fact that contracts are a risk mitigation tool, and they become then a very important aspect of business transactions. And therefore, a well-drafted agreement is the very foundation of business relationships. It not only safeguards business interests, but also fosters trust and accountability, and even possible cost savings as a result of the absence of uncertainty. Okay, what are some of the common pitfalls in contract drafting? I would circle back to what Irene said, which is that sometimes you read a contract and it's obvious that the key elements, the essential elements that make up a valid contract are missing from that contract. So those are the elements of offer, acceptance, consideration, intention to treat, as well as legality. A lot of these problems arise from, to put it bluntly, carelessness, failing to tick off these important elements, starting with the basics. But then there are certain complexities that are now the second level of drafting and review, which is that you must consider the form of the contract. And once you have determined the form of the contract, it would then dictate the language that you use in that contract, the substance that makes up that contract, as well as the processes that must be adhered to. A very good example is employment contracts. Now, each of our jurisdictions have their own specific employment law. And that employment law dictates the kind of employment contracts that would be deemed to be valid. If I can just juxtapose that with sale of goods contracts. Again, our respective jurisdictions also have their sale of goods law. And therefore, in order for title to pass, for example, it has to comply with what statute provides. Going further, then, how do you ensure that you're ticking off the correct boxes in order to avoid the pitfalls in contract drafting? Well, then the first thing is to establish a clear understanding of the terms and conditions between the parties involved. The basic would then be, have you done your preliminary work? A lot of our drafting starts with the review of a term sheet. In my line of practice, we are involved in the drafting of those term sheets. So by the time we are going to the review of the substantive documents, we are aware of the commercial agreement of the parties. And then, as many of you know, term sheets are typically non-binding. They essentially just set out the preliminary commercial agreement between the parties, but they do contain certain terms that are binding. Like, for example, the confidentiality agreement or the confidentiality clause. Another one would be governing law and jurisdiction. Another one could possibly also be dispute resolution. A key part of understanding the terms and conditions, as I mentioned, is also understanding the sector that the parties are operating in, whether it is a regulated sector. For example, if you're dealing with lending contracts and you're dealing with a bank and a borrower, and obviously there are certain banking act or banking law considerations that come into play, which you must honor. A good example would be the induplam rule, for example, that you cannot charge interest in excess of the principal. If you're reviewing a lending agreement where you can see the interest would exceed the principal, then obviously that is an illegality at the outset. The second would be the issue of defining the rights and obligations and possible exit options of the parties, which we typically call termination. There are two ways to look at this. So on the specific issue of termination, one could be the provisions of the termination clause. But then again, from experience, in review, you could see certain events that happen that extinguish the substance of the contract. Let's talk about certain, say, sale of goods contracts. Once title passes, it passes with certain rights of the parties. And therefore, depending on how the contract is drafted, then it would dictate the rights of the parties at any one time. As was mentioned by both Irene and Robert, you have to adequately address risk allocation. And in the project's practice, when you're dealing with project finance and project development, risk allocation is critical, simply because of the punitive consequences of not properly allocating risk. Many of you know that a lot of these projects, infrastructure projects, are multi-billion shilling projects, where if you fail to properly allocate risk, then the loss would be such that it would nullify the ability to continue the project. We typically, to address contracts where risk is so critical, have a risk mitigation matrix. And through this, we would then list all the key or the critical risks attendant to that contract or that project. And then the matrix would then allocate those risks to each party. And then we as lawyers would then now take that risk allocation matrix and draft the contract to reflect how risk would be managed and shared between the parties. But then again, there are certain ways which we need to factor in that, yes, we have risk allocation, but how do you then mitigate risk? As Irene mentioned, one of the tools to do this is through indemnification and limitation of liability. Now, let's take a step back, because not everything is negotiable in a contract. It sounds strange at the onset, but you have to look at your client's negotiating position. A good example of this is in banking. Again, the bank typically has the stronger hand to dictate the key terms and conditions of that contract. The borrower only has a strong negotiating position if it is a large borrower. So when you're representing your client, you can waste a lot of time negotiating things which it is a lost cause to try and negotiate because of the negotiating position of your counterparty and that of your client. It also goes back to the issue of your strategy of negotiation. You could then, from experience, it's better to agree with your client what things you're willing to concede and what are the non-negotiable points for you, as well as those points which, if you negotiate, you can cede to a certain degree, but this is the point at which you would retain certain rights and benefits under that contract. As I will reiterate that it's so crucial that we ensure that the contract is enforceable by a court of law. You typically tick off this box by, the offer, acceptance, consideration standard, the basics. But also, as was mentioned, say simple things like governing law or jurisdiction can make this point very complicated. Lastly, let's never forget that contracts are a commercial tool. So they must be customized to meet the specific needs of the parties. And once this is done, then the contract can then be a means of fostering trust and accountability between the parties. One of the things that we see a lot of litigation or disputes on is the scope of the contract. And therefore, in order to mitigate this risk, then it's critical to have a very clearly defined scope. And sometimes we forget that the term of that contract is also part of scope, that it's not a contract that is continuing in perpetuity, right? Another critical aspect of scope is defining the specific tasks, the deliverables, and the milestones that must be met by the parties. And then now this comes to process. It brings us to the point of process. What mechanics do we need to employ to ensure that those deliverables are met? Again, I will use a project development example. Under EPC contracts or engineer, procure, and contracts, you have to deliver the project up to a certain quality, and therefore you must follow a certain process. That is typically set out in either the body or the schedules to the agreement. And then there's the substance. I think Irene talked about how contracts are structured, the introductory section where the parties are set out, the recitals, and then the substance, and then boilerplate. This substance is where we as lawyers, in my opinion, should spend the most time. Is the substance of the contract capturing the commercial agreement of the parties? Where it does, have the risks in the transaction been properly reflected? Are there agreed on mitigation options that can be included? I say options because you do not see indemnity clauses in all contracts. Sometimes your negotiating position as as a party precludes you from having it. We recently came across or recently dealt with such an issue in a lending contract again, where you know, the borrower wanted to be indemnified, for example, if drawdown does not happen in a certain period of time. And of course, the lender was like, absolutely not. So on the flip side, the lender then had the ability, were able to then enforce their right to indemnification should the borrower not meet certain standards. Moving on, the issue of payment and consideration, I think that has been covered really well. I won't reiterate it. But there are certain things that we need to remember. Confidentiality typically forms an agreement on its own once it's entered into the contract. And it's critical that you ensure that these clauses are there, where particularly you're dealing with clients who have trade secrets or commercial interests that are not in the public domain, which, if they are disclosed, would severely hamper their commercial interest or operation. Indemnification, I will not reiterate. Best practices, we've gone through this, but let's focus on avoiding common pitfalls just through the issue of clear and concise language. In training, I was informed that, you know, as a lawyer, if you can say something in 5 words, do not say it in 15. Because the more verbose your contract is, the more difficult it will be to understand. There is a caveat in this, though, which is that you want to set out your terms with enough specificity that removes ambiguity. So that's really critical. Finding that balance and equilibrium is so critical. Dispute resolution, both my fellow panelists have touched on it. But from my experience, you know, you do not randomly pick a dispute resolution forum. You have to look at the industry that you're dealing with and the case law that that either supports your position as a party or would then direct you to another dispute resolution forum. And then lastly, the cost to your client of choosing a specific dispute resolution forum. Let me give you an example. If you want to go the institutional arbitration route, you would be then backed up by, you know, tried and tested rules. And then in addition to that, they typically have very good arbitrators or ADR practitioners, but the cost can be exorbitant. So you would only go into certain forms of institutional arbitration, the ICCs or the LCIAs, if your subject matter is such that it justifies spending that amount of money on, you know, on institutional arbitration. If you are a lender, then you do not want to choose ADR because we have a big body of law, case law in the courts that supports you. So you'd want your dispute to go before the courts. On termination clauses, this typically, sometimes we say either party can terminate. But then again, take a step back and consider what are the commercial interests of your client. Because if your client has already expended its input into the contract and you're giving the other party the right to walk away at their discretion, then it would not make commercial sense for your client. Always stop and consult with your client once you get to the issue of termination. You know, either party can terminate at any time at their discretion. It sometimes would be redundant to the type of contract you have and the commercial interests of your party, of your client. Renewal, it was previously touched on. sometimes we have this automatic renewal clause, but the position of the parties could have changed. The commercial interest of the parties could have changed before then. I very much agree with the idea that you have certain provisions that are subject to review and agreement before renewal. Okay, the use of templates has been touched on, but let's also remember that these templates exist because they've been formulated over time based on standard market practice, as well as case law that has been developed through the years. So here at Oraro and Company, we have one of the largest, if not the largest, dispute resolution team in the country. And because of that, we're able to monitor, how matters are being churned out through the commercial courts, what is being upheld, what is being constantly challenged. And as a result, we are constantly updating our templates to reflect or to foolproof what is currently in the market, so that we're not a step behind. And that is why clients come to us to ensure that contracts are up to the level of a market standard, and number two, they can stand challenge in the courts or through ADR. Okay, so I'll go quickly through this. Data protection has been touched on as one of the trends to note in contract drafting. So as recently as 5 years ago, 10 years ago, we were not focusing so much on data protection in our contracts. Now it is a standard issue that appears in a lot of the contracts that we're dealing with, as well as contract negotiation, not just in Kenya and East Africa, but all around the world. It's also something for which there is now a robust statutory and legal framework. So there is an expectation that there would be adherence to data protection principles. The use of e-signatures is something that came up during the COVID era. But you have to remember that if your contract provides for the use of e-signatures, it has to comply with the statute that backs up the use of e-signatures in your jurisdiction. Lastly, there is the rise of digital or electronic contracting. We typically deal with it even on a day-to-day basis, where you accept terms and conditions. If you are helping a client draft the terms of these e-contracts, then on a preliminary basis, you have to remember that not all contracts can be e-contracts. For example, here in Kenya, by statute, all contracts for land must be in writing. All contracts for securities must also be in writing, physical copies of that contract. That's what I mean. And therefore, it cannot fall in that bracket. I believe it's the same throughout East Africa. Okay, so to wind up, contracts are exciting, and they're not all about legalities. They have to give effect to the commercial agreement between the parties. And because of this, they are a strategic tool. And well-drafted contracts should be an effective risk management tool as well. So understanding key clauses and navigating potential pitfalls, as well as mastering the art of contract negotiation, are all an important part of contract drafting. And therefore, I conclude by saying that the drafting and reviewing of contracts is a unique blend of legal precision and strategic alignment. Thank you very much. Happy to take questions. Ruth, back to you.
Thank you so much, Cindy. That was quite informative. In a nutshell, we can note that we must have a clear understanding of the terms once we come to contracts. There must be a clear legal framework. You need to understand the risk mitigation matrix. What can your client concede? What can't they concede? What are the non-negotiables? Thank you so much, Cindy, for taking us through that. We are now at our plenary session, and we must agree that contracts have been existing for years and years. In fact, I don't know if most of you know that there's a 4,300-year contract written by Sin Ishtar to purchase a slave known as El Tapi. And when you look at it right now, from a humanitarian perspective, it sounds very offensive. In fact, it is very offensive. However, it goes to show you how contracts have been there from way back when. And it shows how the legal advancement was there back then. And we are so grateful to have had the three panelists who joined us today. And we are now ready to be taking in questions. We have now entered into a plenary session. So perhaps if there's any questions, you can share them on the chat or on the Q&A, and then I'll take them up. Or you can raise your hand so that we can unmute you so that you can pose the questions directly to the panelists. I'll start with Irene. There's a question here for you. What advice would you offer to an advocate acting for a party with no bargaining power, such as a bank customer and a bank, since they have standard contracts that basically indicate take it or leave it? So Irene, I'll take it back to you.
All right, thank you so much, Ruth. I think we had tried to answer Lydia's question in the chat. Lydia, yes, most times it looks like the contract is take it or leave it, but you do realize we have the consumer protection guidelines, and that is the purpose for which they were put, because before then banks were taking advantage of the clients, and that's why now they are mandated to include issues to do with literacy, seeking independent advice. There's an issue about cooling off, so that in case you change your mind about the terms, you can cool off. But also, I believe that there is actually room for negotiation. Yes, the terms are standard, but most of them are boilerplate. You do have room to negotiate the things that concern you, namely the interest, how you're going to pay it, because they structure the product and they assume it's what's going to make the most for them in terms of money. But there are aspects of that contract that you can negotiate. You can negotiate your payment terms. It is allowed. And also, if you noticed, in Uganda specifically, the Uganda Bankers Association removed the provision of early repayment penalties. What they're trying to do is to encourage people, anytime you want to pay off your loan before the 10-year period that you agreed to, you can go ahead and pay it without the penalties that were there before. My understanding really is, as one of the panelists, one of the people in the chat said, just have knowledge. That's what I talked about, that as a lawyer, you need to know the legal regime that is around you. It is not true that you cannot negotiate, you can. You just need to know what aspects and what is important for your client that you should go and negotiate. It doesn't make sense to argue about, oh, I don't want you to register your mortgage on my title, yet you have leeway to negotiate the interest. And the interest really is about your bargaining power. I've worked in the banking industry before, and I saw customers who could negotiate. They would come and say, for me, your lending rate is 21%, which would be the CBR plus maybe 2 or 3. And this person says, me, I'm a startup. This is what I'm offering. I'm going to stay with you for the next 10 years until this business is worth XYZ. I'm not going to pay that interest. And they would negotiate. And so they would have CBR plus 1. In some instances, it was even negative. They would have CBR minus 2. So it really depends on your relationship with your banker. That's one. And two, how empowered you are and how much knowledge you have. Thank you. Thank you, Ruth.
Thank you so much, Irene, for that clarification. Now, we have another question which I think probably all the panelists can take time to answer from their different perspectives and their different experience. We are in an era where we have artificial intelligence. So the question is, how can lawyers thrive with the emergence of artificial intelligence in contract drafting and reviewing, considering that now people are going to AI to ask them to do contracts for them? Where is the place of lawyers? What can we do to ensure that we secure our positions? And basically, what is the position of lawyers in terms of the legal basis in respect of contracts? So I think we can start with Irene, then we can go to Cindy, and then we can finish with Robert. This is such a wide topic that I believe all of you have insights on.
Yeah, indeed, AI is a very interesting and challenging topic when it comes to contracts and lawyers. But for me, I think it really doesn't take away the basics that we discussed. There has to be a meeting of minds. There has to be clarity. There has to be, the terms have to be set. There are certain things that AI will not know, the nuances. I talked about culture when I was doing my presentation, certain culture where a handshake is considered a contract. AI may not be able to take into account those certain things. There are small things which may be repugnant to people in different jurisdictions. For me, what I pick out is that it helps us to not forget the minors, the standard templates, because that's what it's going to pick up. And do not forget, AI is programmed using human intelligence anyway. So the two of them have to work together. It can only pick up things that we have already thought about, and then we customize. When one of the panelists was talking, she said, we have to really look at the substantive part of the contract. And that's where lawyers, we put our effort. There are certain obligations or rights that AI may not pick up, because every contract has its nuances. It's different. There are certain, what I agree to do with my client may not be what Ruth agrees to do with her client. So they're small, they're not small. For me, I believe they're substantial. And for as long as people are still doing contracts, AI will have its place. It will do the basics, but as lawyers, we still need to come in and tighten the screws a bit, especially when it comes to the substantive part of it, the obligations, the rights of the parties, what is expected, and how to perform the contract. Thank you.
So I would agree with Irene. I think the only thing I would add is that, we as lawyers are constantly trying to use tech to improve how our service delivery to our clients. And in the West, and even many African law firms, tech is now becoming the second biggest operating cost for law firms. And one thing I've noted is now there are trainings on how lawyers can effectively use ChatGPT and other AI tools in their drafting. Essentially, these AI tools will produce even better templates than the ones that we are manually manipulating, which helps. I mean, it's a cost, number one, it's a cost-saving measure because we spend less time. And also, it will help us start working from better templates, in my view. That said, it's not a substitute for our input to thoroughly review and capture the commercial agreement between the parties. So yeah, it's a double-edged sword. It helps us, but we need to be careful that it doesn't hurt us.
Robert?
Thank you, Ruth. Personally, what I would say is that what AI is going to do is to revolutionize contract drafting, because we are going to have lawyers drafting contracts much quicker, much more accurate. So we shouldn't look at AI as competition, but rather as a partner in delivering solutions to our clients. Because even if you relied on AI alone, still it's you, the lawyer, that interacts with the client. That human judgment that AI doesn't have is with you, the lawyer. Basically, we should be looking at AI as a partner.
Okay, thank you so much,
That's
Robert.
all I could say.
Thank you so much, Robert, for your insights. I think that question was asked by Nana. I believe you have been answered, and I believe you'll be able to use AI to be able to assist you in your dealings as an advocate and in your practice. We have another question here that has been posed to Cindy. How do you incorporate just a minute, how do you incorporate current advancements in law for infrastructure contracts that largely follow standard forms of contract, say FIDIC suites of contracts in construction?
That's a great question. Let me start off by saying the use of these standard forms of contract like FIDIC is really important because then it forms part of market practice. Like I mentioned, when you use these standard form of contracts, then it means that the parties understand that we're not going to start negotiating everything. We understand that in the market, this is the standard. And therefore, we will only negotiate X, Y, and Z. And therefore, even as we incorporate advancements in law, then we are not touching the market, the standard market practice, unless that standard market practice has been challenged and deemed to be an illegality, which at least in Kenya, I'm not aware of any. The good thing about FIDIC contracts, for example, is that they are maintained by a body that is also constantly reviewing legal challenges as well as advancements in law, such that you can trust the template that you're working from. I would say here in our side, in our part of the world, then there are certain types of risks that do not apply, say, in the West. A good example is political risk. So that is something that has been fluid, not because of challenges in court or through other dispute resolution channels, but because of change in government policy. A good example is here in Kenya, we used to have a very open government letter of support. Now we do not have that. And that affects project documents in different ways. Just as an example of something that we would touch and amend to reflect, the current policy on the ground. So, in summary, we rely on the organizations that maintain these standard contracts, but we are alive to certain risks and issues that pertain to our specific jurisdiction. That would then, we would then amend the templates. Obviously, the commercial agreement is something that is you would then draft substantively into the contract.
Thank you so much, Cindy. We have quite a number of questions. So I'll go on to the next one. I believe all the panelists can give some information on that. What advice can you give to in-house counsels to protect the business when executing service level agreements, and how to properly manage service providers who are not adhering to these agreements without ruining the business relationship? We can start with Miss Irene. I don't know if you've captured the question well.
All right. Thank you, Ruth. obviously, managing relationships between in-house counsel and service providers has always been an interesting one. The SLAs are breached day and night, but I think, how do I put it? Make your indemnity clauses, I think, strengthen them so that these people are aware of the consequences of the breach. Because sometimes the laxity also comes from our side. The contract management and supervision may not be as you know, as apt as it should be. So strengthen that, ensure that these people understand. Do some training before you onboard the service providers. Do some training. Let them know the impact of their non-compliance with their contracts to the business. Because if you bring them on as not just service providers, but partners in the business, they know their role, that anytime I'm supposed to provide a service and I am late, I'm causing financial loss to my business partner, which in turn means they can't pay me on time. So if you've showed this person the loop of what their non-compliance or their non-adherence to the contract will do, you're building the relationship, but also ensuring performance of the contract. And the other thing, do not fear to terminate. I know there's when it comes to procurement processes, there's a long process that we go through, but you should be able to have an exit clause so that if one service provider is not performing, another one should come in. Normally, you should have at least 3 or 4 on your panel who are able to provide that service. So if one person is not giving the service, you should be able to transition very quickly to the other one. So in that way, you still manage the relationship, but also ensure that the business continuity, you don't grind to a halt because one service provider is not doing their work. That would be my response. Thanks.
Okay, thank you so much. Cindy, perhaps you can give some insight on this, especially to do with maybe international contracts or where you have service providers from different jurisdictions. What do you have to share to the legal practitioners on this session?
Yeah, so to add on to what has been said, I think, sometimes we focus a lot on the contract, but the contract is only as good as the parties who are part of that contract. And so the pre-vetting, the pre-vetting and the vetting stage is really important. You'd want to have a selected service provider with a track record of delivering to a certain standard. That in itself is part of the due diligence that we hope our clients do. And I find that, aside from contract, you'd want a party who wants to uphold their own reputation and their ability to deliver. Sometimes this is an often overlooked fact. I'll hand over to Robert. Thank you.
Yes, Robert, you can take over. Perhaps you can say something about that.
In addition to the training that Irene talked about, personally, I would suggest that as a lawyer, you ensure you do not forget to address the issue of remedies in that contract. Should any party fail to perform their part of the bargain, yeah. If the agreement doesn't follow up with such and doesn't have sanctions, should the supplier fail do as per the contract, then you're going to have issues. Yeah.
Okay, thank you so much for that question and for the answers that have been given by the panelists. I'll move on to the next question. In what ways can advanced contract analytics and AI-driven insights be utilized to anticipate and mitigate potential breaches or compliance issues? We can start with Irene.
All right. Again, as I said, AI requires HI, human intelligence. So even as we are talking about anticipating and mitigating potential breaches and issues, we need to take into aspect unforeseen circumstances. And for me, I'll go back to leave wiggle room in your contract for amendments, modifications, and revisions. So when you're using AI, it is you to program it and give it the parameters that you want it to look into. For example, you're not going to ask AI to do an analytics for the next 1,000 years. It may not give you that. And yet, as a human being, maybe you could know that every, for the last 1,000 years or 100 years, when we had chicken pox, this is what happened. When COVID came, this is what happened. So maybe if we have another pandemic, this is what will happen, and you can use that. I said in my presentation, you need to be aware and have flexibility in your contract. So maybe that is a parameter you can use when you are using AI to measure or anticipate your potential breaches or compliance and any other issues that come up. I don't know about using it to mitigate, because then I don't know if it would give you the proper solutions. As human beings, you would advise the clients, or the clients themselves would know how to manage any potential issues that came up, because each business or each contract that is being drafted is sort of unique to that particular project. Some projects are going to take different periods of time. Some are going to have a different subject matter, much as the rest of the standard of the templates are the same. But look at what we call the substantive part of the contract. Look at that, and maybe you can use that.
Thank you so much, Irene. Cindy, do you have anything to add?
Just briefly, that AI tools can be used to kind of map breaches, both minor and major. So in my experience, a major brief is typically followed by some steps that would ultimately lead to that major breach. Obviously, you could monitor them without the use of AI, but particularly for clients who have a large suite of contracts, these tools can be very effective for them, so that they're able to properly manage their risk portfolio in their contracts. Back to you. Thank you.
Ruth, do I have the permission to speak?
I can't hear you, Robert.
I was asking if I had the permission to speak.
Yes, you do. Yes, you do. You can proceed.
I was saying that we should use AI tools because they have proved to be very helpful. But as lawyers, we should always remember that should an agreement or contract go bad, AI tools will not be blamed. It is you, the lawyer, so you should ensure that even when you use those tools, do the proofreading yourself, such that your client's interests are incorporated and also protected within that agreement.
Thank you so much, Robert. We have a few more questions here that have been posed to Cindy. However, I believe that it is a question that all the panelists had talked about, and it has to do with data protection. And the question is, can you elaborate more on how data protection clauses are included in project finance agreements? considering the fact that we're in a data protection era, and there are issues that we may need to disclose. There are those that are considered to be private issues that require probably permission from all the parties. How do we mitigate such issues, or how are legal practitioners meant to mitigate such issues or to incorporate them in such types of contracts? We can start with Cindy, and then we'll move to the other panelists.
So data protection does not feature greatly in project finance documents. However, there are some forms of agreements where data protection it's a critical issue. Anywhere where personal information is being shared, which in the project finance realm, depending on the project, you would not see a lot of that. I would give a recent example of, say, energy projects that we are working on, renewable energy. They don't have a heavy data protection element. Where when you're dealing with two business, like commercial parties, then the key issue there would be then the protection of trade secrets, confidentiality, and the like. However, here at the firm, we also deal with a lot of medical institutes, and their data protection is it's a key clause in those agreements. Because even when you're procuring funding, then you have to give the assurance that you will protect the data protection rights of the subjects who are going to be subject to the studies that are being funded. I think over to Irene, if I'm not wrong.
Yes, please, Irene.
I believe Cindy has really put everything into perspective. Project finance agreements and data protection, unless I don't see any proprietary data that would be protected in there. Yeah, so I think Cindy has really answered that question properly.
Okay, we are almost coming to an end of this session. However, we still have one more question that has been posed to Ms. Cindy. It says, can you share an example where overlooking a seemingly minor detail led to significant contractual issues? And secondly, in your experience, what are the warning signs that a contract may not hold up under scrutiny, and what corrective actions can be taken?
All right, no, that's a very good question. I'll start off with, generally, what issues appear minor, but later on they end up being a huge contentious issue. Number one in that list would be definitions. And the reason for this is that in a lot of the transactions we deal with, parties are pressed for time, and therefore they don't spend a lot of time reviewing definitions. And by review, I mean not just us as lawyers, but also the client, that it meets their commercial requirements. So that's typically a huge issue. But another minor issue is just the naming, the wording of a contract. So I've come across many joint venture agreements that are labeled supply agreements. And here in the firm, that very subject has been, it's been litigated on. Because as I mentioned, what is in a word? Like if you call something a supply agreement, then it in substance changes it from what perhaps the parties intended, which is a joint venture agreement, and it would then be interpreted in a certain way. So it's very important to not misalign the form that you use with what you intend to achieve, because it could look like a word, but then it would be interpreted as something else. That's it for me. Thank you. Oh, yes. Sorry, there was a second limb of the question. the warning signs that a contract may not hold up. Hopefully, we as lawyers get this on review. The very basic, I've come across contracts that did not have the element of consideration. So I think sometimes you forget that, or sometimes people forget that, consideration is value. It doesn't have to be monetary. And in that realm, sometimes people call something a contract or an agreement, whereas it ought to be a deed, So, just that's why attention to detail is said as one of the most important skills for lawyers. Another warning sign is just the behavior of a party at negotiation. So typically, contracts can even fall through at that stage. Sometimes we see parties with a weak negotiating position accepting a contract that would later be said to be, in breach of their own legal rights. A good example is contracts that breach the consumer protection rights of consumers. So the negotiating table is a good place to determine whether or not a contract would hold up, in my experience, because we as lawyers can then tick off the boxes, but sometimes clients feel pressed to accept terms and conditions that they ought not to. And they typically do this under a lot of pressure of time. Ruth, I believe you are muted.
Sorry, I'm sorry for that. Thank you so much, Cindy. I don't know if Irene and Robert have anything to add on to that based on their experience or their knowledge before we come to the end of the session.
I think on that second limb of the question, as she has stated that sometimes you look at the behavior of the parties. You see parties don't seem to be agreeing on a certain provision. They don't seem to be agreeing on certain terms, but you still go ahead and have the contract executed. And then again, when you look at the parties fulfilling their obligations along the way, are you seeing a party that is continuously falling short of their obligations? I think those are red flags. And as a lawyer, you need to address them as and when they come.
I'm in agreement with the panelists. I think that is very good consideration.
Thank you so much. We've now come to the end of our session. I believe that this topic of contracts is quite wide. It's not one that we can do in 2 hours, but I believe that our panelists have done an excellent job in digging into today's topic. I believe that everyone who has joined this session has found it very advantageous, has found it very insightful. And even as we go back to our practice, I hope that the knowledge you have gained here will add value to your practice. And thank you so much once again to the panelists, Irene, Cindy, and Robert. We are grateful. We have learned so much. And in a nutshell, what I can tell the advocates is ensure that you have a defined scope, ensure that you have a process, go into the substance of your contracts, ensure that you state clearly if there's any consideration, keep your contracts confidential, indemnify your contracts, and ensure that you stay focused on the goal. Ensure that you limit as much as possible and mitigate the risks, the liabilities of your clients. I want to thank you so much also to the East Africa Law Society for ensuring that this session has been made possible. We will be sharing any slides and the information on your emails. For that, I just want to thank you. You can all leave at your pleasure, but I want to thank you so much for taking your time to listen to us. We will ensure that we plan more sessions that will add value to all of us. But for now, that's all I have to say. And do have a good day and be blessed, everyone. And enjoy practice. Goodbye, everyone. That's all for now. Have a good evening.